All right, with that, good morning, everyone. I'm going to call to order the Town of Ocean Ridge Special Magistrate hearing. Verizon says it is 10 o'clock, so we can get started. My name is Amity Barnard. I'm the Special Magistrate for this morning's hearing. First thing I'm going to do is if you're here to testify on any items on today's agenda, including town staff, I'm going to swear you all in at the same time. So if you're able to, please stand for me and raise your right hands. Thank you. Do you all swear affirm to tell the truth, the whole truth, and nothing but the truth? All right, thank you. You may be seated. A little bit about process. It looks like I think all of the cases on the agenda are violation hearings. So when you hear your case called, town staff typically comes to the podium that's over here or the area over here to my left. You'll come to the podium that's right in front of me. The town will go first. They will present its case, show me any documents. Those documents will be scrolling on the screens behind me on both sides. Um, Call any witnesses they intend to call, present the entirety of their case. Once the town has completed its presentation, it'll be your turn to present any evidence you have, any documentation that you brought with you, cross-examine any witnesses that the town has put on this morning. Once I've heard from both sides, I will make a final ruling and you'll get a copy of an order that reflects that ruling after today's hearing. So keep in mind that all of your testimony today is given under oath. For the record, I did review the January 6, 2026 meeting minutes and I approved those as drafted. And with that, I'll turn it to the town to call its first case.
Thank you, Your Honor. Christy Gatto on behalf of the Town of Ocean Ridge. Your Honor, the first case on today's agenda is case 2026-002. The respondent is Robert Calgagno. We have Officer Pylon here present for the town and the town clerk, as well to testify on behalf of the town.
Your Honor. So in reference to this case, Your Honor, on January the 26th, actually, this is the date this is about it. January 26th, I was informed that a case had been opened in reference to a tree permit or a pruning permit for the listed address. It was initially assigned to Sergeant Ermery, who conducted a preliminary investigation. I believe he found there to be one violation in reference to failing to obtain the proper permit before pruning. As a certified code enforcement officer, I was asked to review it to see if there were any additional violations or any other issues that were going on. While doing that, I did find that there were a couple more violations that took place. There'd be four exact. One would be the pruning, obviously without the proper permit, removing the vegetation from the dune. The other one, based on the size of the sea grapes that were removed, they considered them a tree because of the size. The other one would be the windowing and just the length in which they cut the sea grapes. And the fourth one was just the method in which they actually trim them, which is considered hack.
And Sergeant Pylon, did you provide service to the respondent?
I did.
And how was that done?
Hand delivered.
Okay.
What date did you do that?
I'd have to look on the form. It's if you could scroll to the top because I don't remember the exact date. It wasn't the same date I prepared the packet, I don't believe. I believe it was the 18th. Yeah, February 18th.
Okay.
And during your investigation, why did you decide on the respondent, Robert Calgagno?
When doing the search of the property, he was listed, his address was listed pretty much as the primary one. There is no, that I could find, there was no office address or association address or name associated with it for some reason, which is usually, it's odd, but he was identified as the president. And I believe he was the one who admitted to having the work done. as he stated that he believed that piece of property to be property of his association.
So it's a condominium building or something?
is, yes.
Okay.
And to your knowledge, is the property where this, the violations occurred, condominium association property?
Not based on what I found through my research through the property appraiser, which I've included on here as well. Which is what I know he claims to have some deeds or whatnot, or I think there was some confusion about what property is the town's and what's his. But based on my research, it is technically the town's property.
Oh, so you're alleging that they cut
If
sea
you
grapes
scroll
on the
along,
town's property?
If you look right here, the red window that I picked out for you, so the blue line would indicate their property ending, right? So in between the walk, which you can't see that well, but there's a crossover right there. To the right of it, all that vegetation is what was cut, which I think he believed was on their property.
So you're saying on the was that the north side of the boardwalk there? Is that what you're
The
talking
south
about?
side, yeah, exactly, right there.
Right there, okay.
And in your experience, working as a police officer for the town, had you been past this area before?
Yes,
And, based on your prior observation of this area, was the vegetation, there taller than 6 feet?
absolutely. There's actually a photo, prior to this, in there as well, that will give you a depiction of what it looked like, before it was actually trimmed. That's okay. To the right, if you scroll over, that's what it looked like prior to trimming.
And does that photograph fairly and accurately depict what the vegetation looked like prior
does.
to trimming?
It does.
Right, any further questions? Town attorney? All right, so can you go back to the code? What does the code say?
Which, you.
So
it has
I heard you
four of them listed.
Yeah, so just walk me through
No
the
worries.
one that I'm a little confused about is the permit.
Okay, so there's a permit for any planting or removal of vegetation from the dunes. The town requires that you retain a one-time permit, I'm sorry, once a year annual permit. You have to get that in order to do any type of just maintenance pruning of the vegetation, which they didn't obtain.
But would that apply to town property? You would approve a permit for someone
So
to?
we also, in our codes, we have a resident can remove a tree from town property with the permission of the town manager. And again, that would be a permitted process and they would have to follow those steps.
All right, so it does apply to bushes and trees that are on town property.
Yes.
Okay.
So if you had something that was obstructing your view and you wanted to move it, you would get approval from the town to do so and then you'd have to go through that process.
Okay. And then the hat racking is,
Yeah, so the
I
hat racking
understand
is
that.
just the method in which it was cut.
and walk me through I saw some pictures of the measuring tape around the
Yep, so
tree trunks. So what's,
if the ordinance depicts a tree being certain sizes to be a tree. So with the sea grape, it can be either a hedge or a tree. And that's determined basically by the size of it and the method in which it is. So these were clearly in excess of, like I said, one was over 20 inches in diameter. Which the ordinance says is a mature tree.
if it's over 20
Yeah,
inches?
yes.
Okay.
And the height as well. So it was actually, I didn't measure it beforehand because it was already cut. Just so my guesstimation was it was anywhere between 12 and 15 feet tall. So these were all cut down, part of the hat racking, they were all cut down below 3 feet in height. Which is another issue because anything that's pruned, any of the sea grapes has to be 36 inches or more.
Okay. All right, is the town calling any other witnesses in this case?
I'm not at this time, Your Honor.
No. Good morning, sir. Your name?
Good morning, Greg McAloon, Sachs Kaplan.
Spell your last name just so I get it right in the order,
Of
please.
course, McAloon,
N or M?
N as in Nancy.
As in Nancy. In your counsel, correct?
Correct.
And you represent Mr. Calgagno? Or you,
Calcagno and Portofino of Ocean Ridge as well with it.
so you represent the association as well?
Yes.
Okay, so let's start with the easy part. You've seen the documents that have scrolled on the screen on both sides of me. Do you have any objection to those documents being entered into the record?
No objection.
Okay. All right, do you have any cross-examination for Officer Pylon?
Not for the officer, but if I could proceed with.
Sure.
the
Yeah, I just wanted to give you an opportunity while he's standing there.
Yeah.
Oh, yes, go ahead, sir.
Certainly. And I appreciate everyone's time. I do want to start off just for the fact that this was issued in the name of Mr. Calcagno. And it was the association that did it. So I don't want to make that the crux of this argument, but I just want to point out the fact that, it was the association who engaged the landscaper and all that, and not Mr. Calcagno individually. Again, it's not the crux of the argument, but I just want to mention that from the outset. Essentially, this matter relates to a routine trimming of sea grapes on an area which is a portion of association property and directly adjacent to, for which I understand they have conducted routine maintenance over the past 18 years within this relevant area with it. The association did just engage a new landscape company within the past year. And it's expected that any of the consultants retained would go through the proper process and approvals in order to go about trimming with it. Additionally, the sea groups had become overgrown. They've become somewhat of a nuisance with it. There was an issue related to visibility, increased vegetation, and getting in the way of bikers or bicyclists, I should say, and causing an issue. I know under state statute, there's a rule if you have a certified arborist letter for single family and duplex properties and it poses a dangerous condition, there is the authority to remove. I acknowledge that applies to single family and duplexes, but I do think it's persuasive in terms of statutory guidance and how these matters are typically conducted when you have a certified arborist letter saying it causes a danger to persons or property with it. At this time, I would like to submit a letter from the arborist, certified arborist, as well as the landscape company into the record, if I may.
Sure, give it to Officer Pylon first and he'll give it to the town attorney before I look at it and I'll get their objections. And while you're going through the paperwork process, is that all you have in terms of evidence, or do you want to get?
I have additional pictures as well. They'll require a separate explanation, but I could also submit those for, time
Yep,
purposes.
that'd be great. That way we can do that, and then you can give me whatever explanation
That's
that.
fantastic.
Yeah,
Thank
that's
you.
great. Thank you. Any objections?
Your Honor. The town would object in the stance that these are both after the fact documentation from the landscape company and a certified arborist regarding trimming that was done. So it's not done prior to the trimming to say whether the trees that were cut down, the shrubs that were cut down were a danger to persons or property. Certainly the arborist letter doesn't appear to address a danger to persons or property. It merely just is addressing how the trimming was done. So we would object to this, to it being relevant because it's not consistent with state statute, which is only applicable to single family homes regarding the removal of a tree if it's a danger to person or property. So I don't even think it's relevant. The letter from the landscape company simply says that they received complaints, but as you can see from the pictures, the prior to the trimming, what was there is not directly on the roadway. So if there was an argument that this was a danger to bikers or pedestrians, certainly someone from the condo association could have come to the town and said, hey, we're going to apply for a permit because we think this is an issue. That's not the facts here. So
Okay.
I think both are irrelevant.
Okay, and then the photographs?
Um, yeah, we have no objection to the photographs, Your Honor.
All right. All right, I'll go ahead and I'm going to admit everything over the town's objection just so I have an opportunity to review it. And I understand her argument that the timeliness may be an issue, but I'm going to go ahead and let it in and let me just read over it very quickly.
Yes, certainly. Thank you.
And when are the photographs from?
Yeah, certainly. One's a before photo of the area in question. One's an after photo of the area in question. One
Is
of them.
that this you're talking?
Oh, no, that was
No,
the
that's just
attachment to the
attached
arborist letter.
first.
That's the before photo.
Okay. And is it from January 30th?
Yeah, approximately.
Okay.
And then that should be the after photo. I took that photo a week ago. And that's the view from the boardwalk showing each side. And we're maintaining that the one side is a 3-foot hedge with new growth and vegetation coming out of it. And the next photo, it's either the public or private walkway. That's the public walkway within the town. That's located, I think, approximately 5450 Old Ocean with it. It just shows that both sides are consistently cut to a 3-foot height, maintaining a consistent height throughout the dune and these relevant portions. So it's for purposes of showing other boardwalks in the area, maintaining a 3-foot height on both sides of the walkway.
Okay, and this was from last week as well?
Yes, I took that photo and I took the next one.
Your Honor, I didn't realize that photo was from a different dune crossover. We would object to that being irrelevant also to the issue of this crossover, because this crossover has, as you can see from the prior pictures, extensive vegetation different from those.
All right, noted. I'm gonna go ahead and let everything in, but I know your objection for the record.
That's private property, same considerations.
Okay.
One was a public walkway, the other's a private walkway, just to show different examples.
Okay. And the photographs that the town submitted are from what date? Are all those February 13th? Okay.
Except for the one that's the prior.
To include all.
All right, go ahead and continue.
Thank you so much. Again, it's to show that there's new growth in vegetation. As shown within the arborist letter, the trimming was performed consistent with acceptable practices. Importantly, the sea grapes remain alive, viable, and structurally intact with it. That's important for the hat racking charge with it. Hat racking in the traditional context is for unique trees such as an oak, a Japanese fern, which are cut in such a way that they're effectively destroyed. As shown by the arborist letter, these are not effectively destroyed and they do have new growth. I was also out at the property with the clients last week and they did show some areas which was there was pre-existing dead trunks with it as well. So essentially, we're seeing new growth and we believe that many of the lowered ones with it were predated the cutting with it as well. So that goes to the point that hat racking is typically for unique trees. A sea grape has its own section for it. I understand the distinction that's trying to be made between a hedge and a tree, and I respectfully disagree with it. I do think that there's a code section already which governs sea grapes, which says if it's over 6 feet, it could be cut to 3 feet with it. Essentially, the arborist confirms that the pruning promotes healthy growth and long-term sustainability, and that they found that the sea grapes were not essentially destroyed with it. Again, as shown in those pictures, there's a 3-foot height around other boardwalks in the area with it. This is consistent. This is consistent with what I understand the association has conducted through their prior landscaper for the past 18 years with it. Again, I think that this is simply a matter of, retaining a consultant and expecting them to carry out with the duties and actions with which they're required with it. They are new to the situation with it, and this will certainly never happen again without speaking to the town first. I think coordination is the proper way to go about it with it, but I don't believe that there's been a hat racking pursuant to the arborist letter, and I don't believe that the height has been cut outside the confines of the required code as provided in the arborista's letter. The association acted in good faith. They want nothing more than to maintain a beautiful scenic walkway for both their, residents of the association and the residents of the town as a whole as well. What we'd respectfully ask Your Honor to consider is, the association's responsibility to maintain safe and adequate common areas. I understand the town's position regarding the minor piece that may or may not lie just outside that area, but that would be subject to a landscape survey showing where each tree and location are. The root barrier systems are completely intact, allowing for the new growth with it as well. And if the association doesn't maintain common areas, they face liability from their residents because they have obligations under their declarations to engage in maintenance of their relevant properties. It was done uniformly. It is a straight hedge all the way across with it. Again, from the picture shown, there is new growth taking place with it as well. And there really hasn't been any type of destruction of these sea grapes as exemplified by the recent pictures. There is some new growth coming in at play. So the association was proactively engaging with this landscape company who took over within the year from their previous one. And again, I think it was just a miscommunication with the landscaper as to what would have been required. And we'd like to make sure and work with the town that this never happens again and that they can maintain their areas within a beautiful and scenic area. So we'd respectfully request that no violation be imposed, but if it does, consider the mitigating circumstances that I had mentioned with it. And we would like to work with the town to make sure that any further pruning has the year in advance with it, and that this landscaper is aware of all processes and procedures to maintain a beautiful area for both the residents of the association and the town itself.
Okay. So let me ask you a couple of questions. I'm
course.
not understanding in this photograph that you provided, where is the issue with the bicyclists and the pedestrians? It does not appear that the landscaping is hanging over into the boardwalk. So where are people walking and bicycling that these bushes are impeding?
I understand there's some overhang in the
Your
front.
Honor, I have an objection. If he wants to present witnesses to testify as to these facts, I think we need to hear from the witnesses and not the unsworn statement of their attorney.
I'd be happy to do so. That's fine.
Okay.
All right, do you have somebody?
Yes, Mr. Calcagno, and this is, Mr. Calcagno with the association. He was the named person on the violation with it.
Okay.
So I'd like for him just to talk about what he's hearing from residents and just past issues that have occurred.
Great. We could put him, I don't think he's under oath. Did you swear in?
Do you swear affirm to tell the truth, the whole truth, and nothing but the truth?
Yes,
Thank you, sir. Your name for the record?
Robert Calcang.
Thank you. So go ahead.
You see this photo that we're looking at right now?
Yes.
Do you think that's been maintained by the town? That recently been maintained by the town?
Well, so
My has been clearing that property for 18 years,
okay.
maintaining that property for 18 years. Beer cans, bottles, napkins, wrappings to sandwiches inside of that area are very, very visible. They're actually back there again since we have not been maintaining the property since the violation.
Okay. So let me ask
There is
you,
also,
in this photograph, so the evidence that your attorney presented indicates that there was an issue with pedestrians and bicyclists not being able to access the walkway.
in 2023, May of 2023, Portofino was part of a third-party lawsuit. Actually, our insurance company paid out a claim. Two gentlemen were riding the bicycle off of that walkway out into the sidewalk and were allegedly or somewhat sideswiped by a car, and they sued us. There was no vision of the street. When those sea grapes get high enough, when you're coming off that walkway onto the pavement, you don't see cars or other bicycles passing.
Okay.
If you move the photos, you can see that actually. You'll see before. There's also in one of the photos where they claim hat racking, there's 3 photos of vegetation there that has been dead probably for the last 6 or 7 years. The center of that vegetation actually has termite damage in the middle of it. There was no trees but sea grapes that were cut down there. And I asked the town in good faith, I saw the town manager. I met with her and I asked her to provide me with proof that that property belongs to the town. And she submitted a document with that doesn't show clear ownership of the town of Ocean Ridge. What it is shows that it's part of a tax map. But experience that I have with tax maps, there are many tax maps that are right in the middle of people's living rooms. Tax maps don't give ownership. Recorded deeds do, and they're not able to provide a recorded deed. I specifically came here myself, I'm from the building line, and asked them to give me that, and they cannot provide a deed that says that that property was given to them, the town of Ocean Ridge. The truth of the matter is there is a walkway there that used to be our property. Is there a possibility you can pull it? There's a walkway that goes from A1A to old A1A, which was our property. We gave them well, they don't call it an easement, they call it beach access road. That was our property originally. We gave that property to the town because that used to be, they would walk through sand and dirt. We gave it to them, and there was a deal made that giving that easement to them would get a commercial piece of property approved, because there was a restaurant where Portofino is now. It was called Bush's Restaurant. I asked them for proof of that, and they say that I got two different answers. One time when I went way before this, they told me that there was a flood in the town hall and those documents were destroyed. Then when I went back recently and sat with the town manager, they showed me a document that's clearly not legible. I have been maintaining, my development has been maintaining, clearing that property up. I'm living there 26 years, but I've been on and off the board for the last 18. We have been maintaining that property. Now, since this situation has come up, there's some kind of contractor or they hired someone to clean it, but we were taking care of that property for 18 years that I know of, and probably way before that.
Okay.
We are at default because the landscaper changed. Went from, we just got a new landscaper within the past year and has not been able to get a tax stamp that's needed. So I went to the town. When I met with the town manager, I met with this young lady here in the red, and she told me that I owed a fee of $300 for the last two times that the sea grapes were cut. And I provided that check within 24 hours for
Okay.
the two times that the sea grapes were cut without a permit. During COVID, it would take 6 to 8 months to get a permit to cut any sea grapes there. Okay,
From the town or from someone else?
from the town. Okay, it's not, in the past, the sea grapes, when they were cut, we never had a landscape apply for the permit. We had a management company apply for the permit. We no longer have that management company. They retired, and we have a new management company. I was not aware of that. The management company was applying. I
Okay.
think if we were to ask that, Kelly, she can tell you that since this recent new landscaper, we've had a problem to apply for a permit, but I clearly paid the fee.
Okay.
Thank you.
Thank you. Let me stay there for 1 second. Madam Attorney, do you have any cross-examination for this witness?
Yes, I do. So is it your testimony that for the last 18 years, all of this area was maintained by the condo association?
Our area, all the way up to the walkway, has been maintained and paid for by Portofino of Ocean.
So up to the wooden boardwalk that we see?
Yes.
Okay.
Test.
So can we go to the photo from the Google Map photo? And so this Google Map photo showing the vegetation prior to it being cut down, this is how your company or your association maintain the property?
No, we cut that. That grows very, very fast. We've been cutting that for
You-
18 years.
For 18 years. So if the town testifies that in fact that property, that area next to the boardwalk is right of way, town right of way, the town maintains it and has allowed it to grow to that extent, that would be incorrect?
That's it.
Okay. In the 2023 lawsuit that you mentioned, the issue was on association property, correct?
The gentleman that came off of the walkway came out onto the pavement and was struck by a vehicle.
So the association paid out for
And
it.
they tried to serve the town of Ocean Ridge, and Ocean Ridge said that that's not their responsibility and was never part of the lawsuit. Which I believe if that you owned that property, you should have The town insurance company should have paid on that claim, not us.
So are you saying the association paid on a claim on property that
We
isn't
were part of
theirs?
We paid a claim off of that walkway into the street. And it actually raised our insurance quite a bit.
Okay, so you're saying your association paid a claim for an accident that
Our
occurred on
insurance
someone
company.
else's property?
That walkway clearly belongs to the town of Ocean Ridge. That property to the right, north of that bridge, does not belong to the town of Ocean Ridge. That's what
So
I'm saying.
you're claiming that the property line is right next to that wooden boardwalk that goes across?
If you line up that white sign with the middle of the beach access easement, that was clearly our property before we developed it.
Do you have the beach access easement with you?
Excuse me?
Do you have the beach access easement with you? Okay,
The town has it.
okay. I have nothing further, Your Honor. Thank you.
All right. All right, thank you, sir.
Can I say one more thing?
Yeah, do you have any redirect that you want him to address?
Regarding the lawsuit in 2023, 22, was the issue related to visibility within that portion right there? And that caused the issues which led to the claim?
We were cited for not maintaining that. They allegedly blamed us for not maintaining that. That's why the gentleman that came off of the walkway was struck.
Creating a visibility issue leading to
There
a
was a
dangerous
visibility
condition.
issue.
Thank you.
One other thing I want to say. If that property, if you were to have a surveyor and you survey the line, you can clearly see that that access road was part of Portofino's property. We gave that access to the town to go from a commercial zoning to a residential zoning. I'm sure that there's a handful of people probably in this room know that Portofino was originally a commercial restaurant. And we were granted the permit with a situation of giving an easement to the town. Sorry, beach access. That was clearly, that entire property clearly belonged to Portofino Ocean.
Okay. Do you, I guess while you're standing there,
Never cut that. If that wasn't mine, which is not mine, I'm just a condo, I'm
Right,
1/18.
right.
I would have never touched that. And I can clearly tell you, I don't have a record of hat racking or cutting things down. That was the property of Ocean Ridge. And they don't have one document that shows how they got the property to that, for that walkway. They
okay,
have that's something that's not legible, that was given to someone else. There's no sign of Portofino. The town cannot find any proof that we gave them that walkway. Thank you.
all right, thank you, sir.
Thank
Mr., how do I say your last name?
McAloon.
McAloon, thank
Yes.
you. Do you have any other witnesses that you intend to call?
None other at this time.
Okay.
And I also just want to add as well, understanding the issues regarding ownership and everything within the confines of the violation, because that's what we're here for as well. We're of the position pursuant to the arborist letter that no hat racking has occurred. And that the height maintains above the 3-foot level for the actual alive vegetation. So I just want to make sure that, we have a narrow focus on terms of what we're here before today, and also that the association is a good faith actor, and we're just looking to mitigate this and straighten this out for the future, so this is never an issue again.
Okay. Let me ask the town, what is the town seeking today in terms of remedy in this case?
Your Honor, in terms of remedy, for the 4 violations that the town deems irreparable due to there no permit being pulled and the vegetation being cut down and hat racking, we're asking for irreparable violation fine amount of $5,000. And for the town's cost, administrative cost of $164 to be assessed.
Your Honor, may I before?
Yeah, just give me one sec.
No problem.
And there's still a permit requirement as well, correct?
Correct, Your Honor.
So you're asking for a respondent to obtain a permit within a certain time frame.
Well, Your Honor, that's the one issue that we have because the town will not issue a permit for the way that they hat racked and trimmed the sea grape trees down in this manner. So a permit can't be obtained in two respects. One, because of the hat racking issue, but two, the town's specific code on dune vegetation addresses how you're supposed to trim the sea grapes that are over 6 feet tall on the dune, and it requires windowing. There's no windowing involved here. It was simply hat racked and all knocked down to below 3 feet. So, Your Honor, we can't issue a permit for something that is done in violation of the code.
Okay. So walk me through what you mean when you say windowing.
So if we go to, and I believe it is in your backup, it may be sort of difficult to read because it's the first page and then it skips a page, but in section 66-161, where there's two violations, subsection A discusses, and this is for dune preservation vegetation. Subsection A requires the permit to remove vegetation. That obviously wasn't done. Then when you scroll down further in that code section, subsection F talks about the sea grape trimming and windowing. And it has below that the diagram showing how on the dunes, the sea grapes, particularly in this case, ones that are over 6 feet tall from the adjacent roadway, are to be trimmed so that you create a windowing effect on the dune itself. And that was not done, obviously. They just mowed them all down. So if the sea grapes on the dune were to be trimmed consistent with the requirements of the code under subsection F, there would be windowing of those taller sea grapes. That wasn't done. And in fact, what was done was hat racking. They cut down a tree that requires a permit to be trimmed and hat racked. It's great that they may be showing some type of growth, but that's not the standard for hat racking. So that's the argument.
And Your Honor.
Yeah, let me, I'm gonna come to you in just a
Understood.
second, but let me just read this code, because what this code section says in F 6616 F2, it says sea grape plants growing higher than 6 feet above the immediately adjacent elevation or more than 30 linear feet along the dune may be trimmed to not lower than 3 feet above the immediately adjacent elevation, except that at least 60% of such sea grapes must be windowed or set aside for future windowing in accordance with the standards set forth herein. In no event shall more than 40% of the sea grapes be trimmed to within 3 feet of the immediately adjacent elevation. So that means that 40% can be cut down to 3 feet and then 60% has to be windowed. Is that-
Right. Now, I don't know if in your backup you have the diagrams
It
that
is there, yes.
there's actually four diagrams that show the windowing and how they're supposed to be trimmed. So over time, you create sort of this window effect on the dune. And that's that violation under subsection F.
But that applies only to the east side, correct? To the side nearest the ocean? Isn't that the idea that they're windowed down toward the beach?
No, it's across, my understanding, it's across the entire dune. So that whether you're on the east or the west side of the dune, there is you're able to see through the trees.
Okay. Okay. All right, go ahead, Mr. McAloon.
Thank you so much. I just first want to address the fact that we have provided an arborist letter report. I have a lot of respect for the town, but I'm not sure that anyone has an arborist license who's, speaking on the issue. So we do have a certified signed arborist letter stating that it's, not hat racked and it was done with, consistent practices. So I just want to mention that again, utmost respect for the town. I just want to point out that distinction. Additionally, as to the damages, I just want to touch on the irreparable and irreversible standard. The only way the town could request that $5,000 is by kicking it into irreparable and irreversible. Under 162, depending on the town size, if it's less than 50,000, I believe the maximum fine per day, and I have to look at the statute, but it's either 250 or 500 per violation. The only way you get kicked into a 5 to 15,000 standard under 162 is through irreparable and irreversible. Irreparable and irreversible, every time I've dealt with it, deals with environmental considerations that can't be reversed. Again, we have an arborist letter saying that there is new growth taking place with it, and the recent pictures do show no growth taking place with it. So I respectfully disagree with the request for the irreparable and irreversible standard. In order to mitigate damages, I would respectfully request that, we do go forward with a permit. I understand what you're saying. I have done after the fact permits before. I don't know how that would work with it. And at most, what I find could occur with it is an imposition of, the one for without a permit at the maximum of $500. So I'd respectfully contend, under the damages standard, we're not under the irreparable and irreversible under 162. Even if there is a violation, in my opinion, the only one that could be found is the one, and that's capped pursuant to 162 at a set amount.
Your Honor, he brings up an excellent point with the arborist report in that I can't cross-examine their arborist. So everything in that is hearsay.
Well,
And
but technically hearsay doesn't apply in these hearings, correct? Code
well, there has to
enforcement?
be corroborating evidence to support the hearsay. It's still a viable objection unless there's corroborating evidence to support it. So even if there's new growth out there, that's not the standard for hat racking. The hat racking standard is not, oh, but if we see new growth after you do it, then it's okay. The provision and the definition of hat racking is you're cutting a tree down without a permit. And that's what was done here. And it's great that there's new growth. We've seen that in other cases where we found an irreparable violation. The whole idea is it violates the code to hat rack a tree in the town. And the whole idea being, and the certified arborist should know this, and it doesn't escape common sense, that the whole reason to prevent hat racking is because you're weakening the tree. Great if it doesn't kill it, but you're weakening the tree overall. So for those reasons, it's absolutely hat racking. They can't get a permit after the fact for something that violates the code. So each and every one of these violations is an irreparable violation. And we could ask for $5,000 for each violation. Instead, Your Honor, we're asking for a one-time violation fine amount for the irreparable violation of $5,000 in administrative costs.
All right, let me ask a question then and follow up to that. So the code says hat racking shall mean to flat cut the top and or sides of a tree, severing the leader or leaders, internodal cuts, or pruning a tree by stubbing off a mature wood larger than 3 inches in diameter, or reducing a mature tree's total circumference or canopy spread by 1/3 or more. So is it the town's position that if a branch is more than 3 inches, you can't cut it?
We have in the past taken that position, yes. But in this case, they cut down, as can be shown in the pictures, the primary stalk of a tree. Not just limbs, the whole tree. And if you look at the before and the after photos, there was as Officer or Sergeant Pylon testified to, a 12 to 15 foot tall tree that they mowed down to less than 3 feet.
All right,
If I may.
go ahead.
I think the unique nature of a sea grape is also adding to the, you know, I don't want to say confusion, but the interesting situation, because as was testified, if it's a certain height, it's considered a hedge. If it's a certain height, it's considered a tree. It's not like a Japanese fern. I've dealt with a hat racking issue on a Japanese fern. That's a tree. This got converted into a tree by nature of its height. Its structure didn't same. And in all honesty, sea grape essentially grows and acts like a weed that turns into a hedge that turns into a tree. So it's just a moving standard, and I acknowledge, again, I don't want to use the word confusion, but I can't think of a better term right now, regarding the overlay between a hedge, a sea grape, a tree, because I would view this as an extension of a branch within a hedge of an existing sea grape rather than a separate tree structure such as a Japanese fern.
And let me ask the town attorney, I mean, I've dealt with hat racking in a lot of jurisdictions. It's my understanding of the hat racking practices. It's not specific to the type or species of tree. It applies to any tree. I understand part of your argument, but there's nothing in the town code that makes a distinction between sea grapes and any other tree. Is that accurate?
That's correct, Your Honor.
Okay. Okay. Well, we're starting off with a bang this morning. Yes.
Your Honor, if I can, and perhaps maybe walk through a couple issues that were brought up by the respondents' testimony. I would like to address the ownership issue. While it's not completely relevant, because quite frankly, they could have applied for a permit on town right of way. I believe the tax map that the respondent was referring to is simply the original plat for this area. The original plat for this area shows that the Porter Street, which this is called the Porter Street crossover, is platted right of way. And if you look at the picture that's included in the backup from the property appraiser, as you're probably familiar with, public right of way does not get ownership shown on it because it's not owned by anyone. It's dedicated right of way. So there is no deed, there is no ownership interest. It's simply right of way. And that entire area between the property to the north and the condominium association property, in this case, is the Porter Street crossover, which has been turned into a pedestrian walkway that goes all the way across to the beach. And I do have, if you would like to see, the plat of this original area showing that Porter Street crossover is a 20-foot platted right of way that is shown here on the property, and it's, as happens to be the case, consistent what's shown on the exhibit presented in the town's backup, that between those two properties is a 20-foot right of way that's never been abandoned, that's still used by the town for pedestrian walkway and goes all the way across onto the beach. While it's not relevant for purposes of getting a permit, it is not association property. The violations at issue deal specifically with, one, not getting a permit to remove, damage, or destroy a tree under 66-151A. It deals with the hack racking that we've discussed at 66-151B6. And specifically as to the dune vegetation, requires a permit, regardless of whether you want to do it on town property or your own property. And it also includes how you are appropriately windowing trees that are grown on those dunes, which was also violated. Since the town cannot issue a permit after the fact to the association because of how they trim these trees, these are irreparable violations for not obtaining a permit. Hat racking in and of itself is an irreparable violation because it's irreparable the damage you've done to the tree, Also along with not having this windowing that's supposed to be now on the dune where these trees were.
And I apologize, may I add?
Go ahead, yeah.
And I appreciate that summary with it, just to go to the ownership with it. And I haven't looked at those specific documents you're referring to, so I don't want to, acknowledge that, but if that's the case with it, it's not true that the association doesn't have an ownership interest. If there's a dedicated plat, there's only subject to an easement with the underlying fee being responsible, and upon such abandonment, the center line of the roadway then reverts to the neighboring property owner with it. It's not traditional ownership with it, but there is an ownership in the underlying fee. If that's the case with it, I haven't looked at the documents. I'm not, saying that, but
I
I
have
did
the plat right here.
no, I know, and I've done a lot of plat work, I've done riparian rights issues, I've done roadway vacations, abandonments, I filed for abandonments and all of that as well. There is an ownership in the underlying fee, if that is even true, the case it is. So just to say that there is no ownership there, which I'm not confirming this is correct, I'm not confirming that's correct. I'm just saying it's not correct to say if that were the case, there is no ownership interest there, because there's ownership in the underlying fee and it's subject to an easement for right-of-way purposes, subject to the specific purpose for which it was dedicated for.
I appreciate that. Thankfully, that's ownership in my mind is not dispositive in this case because
I
it doesn't
agree.
matter who did it.
I
It-
agree.
you need a permit, so thankfully we don't have to get to the
I agree.
ownership issue.
And it is in the name of Mr. Calcagno, we did have the association do that again. That's not the crux of the argument, but I just don't want that point to get lost in your ruling.
And I do want to point out that since the violation, at least the town believes it's on town right of way, we're not seeking to lien any property, obviously. It's an off property violation. So this would be a personal fine against the respondent. It would not be
Well-
against the property.
He wasn't the one who engaged the landscaper, the association did. So there's no privity of contract there either to be able to get to that position.
I believe in the backup, he admitted to the investigating officers that he was responsible for directing this particular work.
Okay,
Through the association.
okay. And another gentleman has approached.
Quick statement.
Were you sworn at the beginning?
I was not.
Raise your right hand for me. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
And give me your name, please.
Paul McNichol, McNicol, and I'm an owner at Wacondo at Portofino.
Okay,
And I'm a broken down lawyer and I'm been trying to advise and help Portofino with this. I feel like we're in a murder trial. It's 15 feet of valuable, wonderful dune and sea grapes. No one cares more about the sea grapes than we do. That protects our property. And I guess what I'm struggling with is fines, no fines, ownership. We'll do what the village wants us to do with that parcel. We may have done it right or wrong, but I would respectfully suggest, why don't we get together and figure out, what do you want us to do with that section? Do you want us to maintain it? Do you want to grow it up to 25 feet? Do you want a canopy? I don't know. I've never heard any input from the village, so we'll do it. Just tell us, as opposed to making us feel like we're criminals, that we attack the sea grapes, which we love and which we are been protecting for 20 years. That's my non-legal input.
I appreciate that. Madam Attorney, do you have any
No, you're
questions for this witness? Okay. All right. The only difficulty in my mind is still the permit requirement. I'm not sure why a permit wouldn't still be required for the portion that wasn't cut incorrectly.
You're absolutely correct, Your Honor. If they could apply for a permit for trimming down the dunes as they did, but we couldn't grant a permit for what they did. We could grant a permit to properly trim the dunes.
But then why did the town cite them for work without a permit after
Because-
observing what they did?
That's technically how we always cite something that you do without a permit, is you did it without a permit. They could get a permit for what was properly trimmed. They can't get a permit for hat wrecking the trees on the dune.
Okay.
And if your honor finds that there's an issue with that argument, then we would assert that the remainder of the violations are established and that we're only asking for one finding of an irreparable violation for $5,000 instead of $5,000 for each violation.
Right, but I guess part of my concern too is that every branch that was cut was not over the diameter, correct? So some of the trees, if they were in fact cut, which there's testimony that they were cut to 3 feet in some places, if those were not over the 3-inch diameter, those were not hat rack trees, right? So that the irreparable portion of this would only apply to those trees that were in fact hat racked.
Correct, correct. If they were properly trimmed, in accordance with the requirements of dune trimming, then you're absolutely correct. Problem is, after the fact, we can't figure out how many trees there actually were. And quite frankly, even if there's just one tree that you hat rack, you now become subject to the irreparable violation.
Right. And what I just wanted to note for the record for you, Mr. McAloon, is your arborist letter doesn't address the portion of the code that talks about the windowing effect. So that's a little disingenuous to say that it meets the code, but not acknowledge portions of that code. And he's not here today, correct?
Correct.
All right, so the town is sticking with its remedy in terms of just the one-time fine of $5,000.
That's correct, Your Honor, plus the town's administrative costs in this matter, which are $164.
All right. And can you go back, Madam Clerk, to the photographs that were taken by the town of the cut trees? All right, stop there. All right. So I understand and I appreciate your last witness's testimony about trying to work with the town. I appreciate that. And I think there needs to be some additional conversation going forward. But what is clear to me here, especially in this photo, is there are portions here that these trees were cut. That's almost down to the ground, right? You see in that, Madam Clerk, can you point to that orange part right there in the center of the photo?
And-
That's at ground level. So that's not 3 feet.
And
right?
again, there was testimony from the client that there was pre-existing dead vegetation there as well. So then we'd have to go and parse out which was cut as a result of that, what's a fresh cut, which was a pre-existing cut with it as well.
I think Officer Pylon could testify whether or not he believed they were fresh cuts.
For each tree branch.
Well, that one in particular, I mean, the cuts look all the same, right? The orange color at the end, that's not a dead, I'm not an arborist by any stretch.
Not at night.
But that does not appear to me to be a dead tree. Officer Pylon, do you have anything to add?
No, they all appeared fresh to me. They were not, I know he said that the arborist claims that they were cut lines at the time. I have to disagree on it because they were all cut in different angles and it didn't seem very well cut to me. It wasn't like they just went straight across the top. They actually cut every kind of direction. That's why I took so many different photos because honestly, it looked like they kind of did a poor job.
Yeah, and that could also bolster the point that there was pre-existing dead vegetation there as well.
Well, but the photograph that you entered into evidence doesn't show, these are all green trees.
Yeah,
So-
but that doesn't show what's underlying beneath it as well. Not each of one of those are from multiple branches. Many of those can come from a single branch.
I think often under trees you find dead vegetation because it's shaded.
Yeah.
Yeah, and the client had just mentioned as well that this wasn't the only area cut. They maintained the whole 250-foot portion of the berm as well. So this was all part of the same trimming process as well. It's not as though they came in and just cut this area. They trimmed the entire 250-foot portion.
Without a permit.
Understood, but it doesn't necessarily mean that it's irreparable and irreversible, kicking it to the heightened standard as well.
Well, my experience with irreparable and irreversible, this is exactly the kind of case that statutory section is used for, because you can't fix what you did. Once it's done, it's done. It's not, you can't undo it. So that's exactly what many irreparable cases are in fact vegetation violations for exactly that reason, because you can't fix or remedy what's already been done. And there's a risk that the trees will not come back. Now, your arborist letter addresses that, but the part that I have an issue with in your arborist letter is number one, as was pointed out by the town attorney, it's an after the fact letter. So had you brought me a letter from an arborist saying, hey, these trees are dead and dying, we need to cut them down, that's a different argument than, oops, we cut them down, here's a letter saying why we did it and how it's justified. The other two things that are troubling to me is that there are general statements in here that are not supported by the photographs that I reviewed this morning. And there's a failure to acknowledge the entirety of the code. And that I don't think is genuine in terms of submitting documents to say that what was done was done in accordance with the town's requirements. And without the arborist here, it's hard to cross-examine
Of course, but
him.
the new photos do show new vegetation growth. That was done, those photos were done immediately after. I mean, the photo that I did submit just does show more greenery than the photo that's on display right now.
Right. And that argument only goes to the hat racking violation in terms of whether or not the trees are likely to come back. But people often misunderstand that when you hat rack a tree, even if you hat rack a 50-foot tall oak tree, green will come out of the trunk that you've cut. That doesn't mean that's the way the tree was supposed to grow. So the same thing may apply here. I don't know. Again, I'm not an arborist. But just because there's new growth doesn't mean that the trees will grow the same way that they're supposed to have grown without the hat racking. But I don't need to get into that today. In terms of this ruling, let me give both of you a last opportunity for final comments. So I'll defer to you, sir, since you're standing there.
Yeah, certainly. And we've fleshed this out as much as possible, I think, with it as well. You see, we have a good faith association who wants to work with the town and does the right thing. They have been maintaining this area for 18 plus years. This was part of a routine maintenance consideration by virtue of a new landscape company as well with it, who may not as be familiar with the town regulation. Again, the association is the one who contracted with the landscape company, not Mr. Calcagno with it. And so what we'd respectfully request is what I believe that this court could at most fine is the failure to obtain a permit, which, we acknowledge and we're looking to correct in any way possible. And, the maximum fine, again, I apologize for not knowing off the top of my head whether it's 250 or 500 for a town under 50,000 people. But I believe that's the maximum that can be imposed. But regardless of that as well, we want to work with the town. We want to make sure this never happens again. And we want to make sure that, there's a good cordial working relationship going forward to where we're never before you having this hour-long hearing over, the state of vegetation on a sea grade.
All right, I appreciate that. Madam Town Attorney?
Yes, thank you, Your Honor. If this area has been maintained by the condo association for 18 years, they've clearly neglected this area and allowed it to grow where there's trees that exceed 6 feet in height. If it decided now to suddenly prune those trees, required a permit, both under the tree permit section of 66-151 and the dune preservation code section 66-161A. Since they did not obtain a permit and they went forward with their landscape work, which was directed by the respondent pursuant to the town's investigation, his admission to them was to hat rack this area and violate both the hat racking provision in 66-151B6 and in 66-161F2. requiring windowing of the sea grape trees greater than 6 feet on the dune. For those reasons, each of these violations is irreparable in that the permit cannot be issued for what was done to the trees. The hat racking is an irreparable violation in and of itself. The dune vegetation permit cannot be issued for the trees that were cut down and the hat racking that was done to the trees on the dune without the windowing. Therefore, Your Honor, we are asking for an irreparable violation of $5,000 for all 4 violations. We could be seeking up to $5,000 per each violation. We are only seeking one-time fine of $5,000 plus the town's administrative costs of $164. I would like to add, Your Honor, that, code enforcement is not supposed to be punitive, but we want to make sure that this association is aware that in the future, when it does plan to trim the dunes or any vegetation in town, it needs to obtain a permit. And that's what that $5,000 violation is, to deter them from future acts like this and to end up back here. Thank you, Your Honor.
All right, and just the administrative cost, is there a cost recovery sheet in the backup?
I believe so. It's the last thing.
About that, I missed it the first time through. All right, 160. All right, so I appreciate everybody's testimony this morning. Let me go back to the administrative process portion. In case PD 2026-002, I'm going to I already entered the town's evidentiary case files, composite exhibit 1 without objection. Mr. McAloon, can I keep these documents for the town's file?
Of course.
I've admitted them into the record. I'm going to mark them as respondents exhibit R2. And I'll ask the town to put these documents in the case file so that they maintain with the case file moving forward. I entered those previously over objection by the town attorney. The exhibit R2 includes the certified arborist letter dated 3/30/26. 4 photographs taken by respondents' counsel and provided, as well as a letter from Tropical Landscape dated 3/30/26. All right, so with all the exhibits appropriately entered into the record, I'm going to make a finding that the town had good service for this morning's hearing based on the affidavit of hand delivery by Officer Pylon and the accompanying affidavit that's in the case file. So there's legally sufficient service to proceed this morning. Based on the testimony that I've heard from both sides, including the president of the HOA, the town staff, all the evidence that's been presented, the photographs are very dispositive in terms of the hat racking violation. I know that there's some discussion in the arborist letter about what is hat racking, but the definition of hat racking in the town code is very clear, and there's dimensional photographs showing that trees of more than that diameter were cut down. So I am going to find the respondent in violation of the listed code sections, section 66-151A, 66-151B6, 66-161A, and 66-16F2. Respondents, HOA president testified to the fact that their landscaper didn't get a permit. So that's, and the town testified that there is no permit on file. So it's clear that the parties all acknowledge that there was no permit obtained for the work. As we've discussed, ownership is irrelevant in this case, whether the town, whether the work was done on town property or the HOA's property or privately owned property, a permit would be required under the town's code section that I just read off. the photographic evidence indicates that the trees were cut down, some of them down to the ground level. So despite what's written in your arborist letter, they were cut down to a height of less than 36 inches, which was testified to by Officer Pylon as well as shown in the photographs that are in the case file. So I have to find you in violation of that section as well. Given the violation, I acknowledge what the town attorney just said. Code enforcement is not supposed to be punitive. However, in cases of irreparable violation, which this certainly is, you can't recreate the trees. They have to grow back. But I'm not going to give you, I'm not going to give the town the fine that they're asking. I think that's a little bit too high in this case. So I'm going to set a fine of $1,500 for this violation. All the violations are irreparable. You can't miraculously get the permit. You can't regrow the trees instantaneously. You can't undo what was done, but I think $1,500 is a more equitable amount in terms of getting everybody to understand that you can't do this going forward. If they do it again and I hear another case from the same property owner, I will certainly not be as lenient, but in this, this is the first time that I think I've seen you all here, so this doesn't appear to be a pattern of behavior. But if I see you again for the same violation, you could expect a higher fine, but I think $1,500 is more equitable. And under chapter 162, because I have found your respondent in violation of the code sections, the town is entitled to its administrative costs, so they're pretty low for today's hearing, but I'll award those in the amount of 164. Those are totally, typically payable, within 30 days. So, neither side is particularly happy with me, which is usually the case as I sit in this chair, but I appreciate everybody's testimony and I appreciate the gentleman's comment that this is not capital murder. This is just a code enforcement hearing, but it is in terms of code enforcement, a little bit more of a severe violation. So I appreciate everybody's testimony this morning. Okay.
Thank you, Your Honor.
Thank you. All right, next case, please.
I think we have only one other or two other respondents here. Sir, what is your case for? A parking ticket. And your name is? Okay. I believe he was here, as the next respondent. His name is Mark Mole, and that is,
Number 8.
yeah, number 8. Thank you. And this is a Sergeant Pylon case. It's a parking citation, Your Honor.
And do you want to read the case number into the record?
Kelly, can you read the case number in? I don't have that up on my screen.
The case number is PD 2026-009.
All right, go ahead.
Um, Yes,
You come to the podium, sir. Yes, sir.
so on, get to the date, I apologize to that. All right, on February 6th, 2026 at approximately 10:43 a.m. While patrolling Ocean Ridge, scroll, sorry. Do you have the photo? Okay, yep, so I was enforcing construction site parking off of Hudson Avenue. And we had been having multiple complaints about vehicles parking alongside that area associated with a construction site. I had moved several vehicles. I tried to warn as many people as I could. This vehicle was left parked out there. I couldn't find who it belonged to. So it was cited for construction related parking in violation of the code. There's a photo of the vehicle parked along the roadway, just to the west of the construction site.
All right, and who effectuated service?
It was left on the vehicle.
And then Kelly provided certified mailing. Town clerk.
Okay, and you got a signed green card back?
Yes, we did.
All right. Anything further from you, officer? Anything further, town attorney?
No, Your Honor, thank you.
All right, sir, your name?
Mark Mall, MOLL.
All right, go ahead, sir.
Um, that was my first time in the neighborhood. I was there to visit that construction site. I, was unaware that there had been any previous parking issues. I didn't see any signage that said no parking. I usually don't, since I don't do actual work, I just have a pickup truck, salesman. I parked a couple houses down because I try to stay away from nails and screws and things of that nature. When I came out, when my meeting was over, I came out to my truck, I had a parking ticket. For some reason in my mind, I just had in my mind that it was 30 days to pay. I didn't realize that it was 10 days to pay until I received your letter in the mail. So here I am today to ask for the present.
Okay. What is the town seeking in terms of remedy?
Your Honor, if it's not paid within the time frame, it goes up to $40 and then administrative costs. Madam Clerk, if he pays today for the violation, are we okay with waiving administrative costs?
I'm okay if the town is, yeah.
So, Your Honor, in this case, we would be willing, since he had the pleasure of sitting through the first case, if he would simply pay the $40 violation fine, we would waive our administrative costs.
And is this what $50?
$50 fine.
Oh, is it 50?
$50 fine.
That's what the paperwork is. All right, so does that make sense what you're hearing from the town? They're telling me that they're willing to waive your administrative fees, which I think is fantastic, given that you just missed the 10 days and should.
If you just pay the $50.
Can you pay that today? Okay. Okay. And you know now going forward where you're not supposed to park?
Well, I haven't been back to the neighborhood since, but I guess where are you supposed to park? Just. Yeah. Yeah, and like I said, I always try to stay away because I have bad luck. I don't want to get screws or nails in my tires, so I always try to park. I don't need to be right in front of the site, so I just park and walk over, but
And that's what I wanted to make sure you explained to him. So not only the construction site, but the picture in here is he's parked on the street, right? So even if it wasn't a construction site, he's not allowed to park on the street?
No.
Okay. All right, anything further from you, sir? Anything further from the
No,
town? All right, in case PD 2026-009, let me ask you, sir, do you have any objection to the documents being entered into the record that you've seen? Okay, thank you. In that case, I'll enter the town's evidentiary case files composite exhibit 1 without objection. I'll find based on the testimony of the officer and the photographs in the case file that the respondent was in violation of section 67-1D. I'll assess or reaffirm, I guess, the $50 fine, and I'll waive administrative costs. So what my order will say is that $50 is payable today. So if you take care of that, that'd be great. Yeah. All right. Thank you, sir.
Thank you.
Thanks for your service.
Thank you. I think the only respondent are y'all here for 7 sailfish? Okay. I think that's the only respondent we have. And that is the last case on the agenda, case number CS 2026-0026. Property address at issue is 7 Sailfish Lane in the town of Ocean Ridge. The nature of the violation is work without permits and inspections. It's been cited as a life safety issue.
That's number 10 you're on?
Number 11.
11.
Number 9 is here as well.
Oh, number 9 is here as well.
Okay.
I'm not sure who was here first. I'm just trying to address y'all sooner than make you sit through anymore. Okay.
So I just want to make sure I'm on the right one. I heard 7 Sailfish Lane, but 11 says 5015 Ocean.
There may be an updated, is it the updated agenda, Kelly? Or am I on the wrong agenda?
I printed the one from, I think I got it in the email last week, so I may have the wrong version. I apologize.
Number 11 is the, yeah, number 11 should be the 50, yeah, sorry, 7 sailfish. Number 10 should be the 50-15.
It may be an updated agenda. Your
All
Honor.
right, so you're dealing with this property address or the violation address is 7 Sailfish Lane.
Yeah, I don't think anything changed with the backup. So what you have is,
Okay, got it. All right, go ahead.
Your Honor, I believe we have our code enforcement officer here to testify. And we have the town clerk here to testify as well, as to service. You want to come on up and testify?
Go ahead, sir.
Excuse me. Steve Shahan, Code Enforcement Officer.
And you can sit if there's a chair
All
there.
right,
If that's,
that'd
I
be
know that's a
great.
little uncomfortable to stand
Thank you.
there. Sorry, Officer Pylon, I didn't say the same to you. So.
Excuse me for the date. I don't see the date. So on March 17th, I was proceeded to Seven Sailfish to serve the notice of violation. And I proceeded to meet the homeowners there.
And just state your name for the record, sir.
Stephen Shahan,
Thank you.
Shahin.
Thank you. Go ahead. Anything further?
I proceeded to serve the notice of violation for those two notices. And unfortunately, I was not able to post or give to the homeowner the notice of violations. We had to, they were not accepting it, and the police had to come and help serve the violation. Once the police came, they allowed me to go up to the house and post it, the violation, because they would not sign for it, the homeowners.
Mr. Sheehan, can you speak to the violations?
Yes, the first one, 6751, is working without a permit. And the other one, and basically it's the Florida Building Code is the other one. Working without a permit, there was a lot of work being done inside the house with no permit. They did have an expired plumbing permit. The town was asking them just to get that situated and active again. And like I said, we were just serving the violation for working without a permit based on what we were told and evidence.
Were they also cited for inspections?
Yes, without inspections as well. I'm sorry.
And can you describe what work was being done? Do you know what work was being done?
It was, for me, on that day, it was hard because I didn't go inside the building. I was only on the outside. Most of the time I was in the street. And then I only went up to the exterior of the wall to post the violation. So I never went inside the property that day.
But they had a plumbing permit, but it's expired.
It was expired. Yes. Correct.
And so compliance for that would be to get that renewed.
Renewed. Yes. And the town was asking for the appraisal. And that's all they were asking for, was to get everything up to date on the permit and get the inspections done, was the appraisal.
Okay. Are there photographs in the file?
just of that day when I was there. I put in the photograph of the posted violation right there, the violation of me posting the violation.
No, but the actual violation, what were?
Your Honor, I believe we have the town clerk who can testify.
Okay, go ahead.
Okay, let me give you a little past history too. So they had applied for interior remodel permit. It never got issued because they had exceeded substantial improvement. We had a meeting with them. We discussed that all we really needed was the appraisal to show that they were within the amount, so they didn't have to do the substantial improvement process. I thought this whole time that they had been getting that appraisal. Then at a previous hearing for, we had a planning and zoning hearing. They admitted under oath that they were doing this remodel and they were almost done. So they had said that they were doing the work. So I had sent, and sent code enforcement out there to stop them from working because they did not have an actual permit. And the other one had been expired. Since then, they have submitted their appraisal. I do have video of a body worn camera that was provided one evening when they were working after hours. I do have an officer. I didn't know how to get it into this file here, but I do have it if need to be seen of them doing the interior work. But where was I? I'm sorry. They did apply for the thing. I did get the appraisal. It is now in review
So
for
they've
that.
applied for the permit?
They have
now?
applied for a permit. I got the appraisal. It is in official review now. The only thing we still do not have is one, inspections, and two, the renewal for the building or the plumbing permit. That has not been done.
All right, town attorney, any additional questions for either
Not at this
witnesses?
time, Your Honor.
Any other witnesses?
No, Your Honor.
Your name, ma'am?
Elizabeth Sapinski.
Who owns this property?
My mother, Yolanda Narkello.
Okay, so you're.
She's away at the moment.
All right, spell your first, just so I get it right in the order, spell your name.
My name, last
Yeah.
name, Sapinski, SCYPINSKI.
I would not have spelled it that way. And what was your first name?
Elizabeth.
That one I could have got. So you're the dog. All right, so the town is telling me you have a permit application in now, you have an appraisal.
That's
you're
correct.
Moving
It's all been
forward.
in. Yes, and we
Okay.
do have an open permit for electrical posted on the site as well.
That's
The
been
plumbing
issued.
permit it's been issued, yes. And my plumbing permit is expired. That's correct. We're in touch with our plumber and he's supposed to be putting in the paperwork to renew that, to get the final inspection done.
Okay, so you're going in the right direction.
Correct.
What's the town seeking in terms of remedy today?
I'm not sure, maybe Ms. Avery can talk about time frame in terms of what this will take to bring it ultimately into compliance.
Once we get the renewal, usually those can get done within a day or two. We just need those inspections done so we can close it out. Because I know they had mentioned that you wanted to get it closed out. The one that's in the official review, depending on, what the officials need, if there should be anything, I don't see it going more than a week or two.
Okay. So if we afford them 30 days, that would be sufficient
I would
time to
think
come into
so.
compliance? So that would be our recommendation, Your Honor, 30 days to come into compliance or a fine of $100 per day thereafter.
Right, and you have administrative costs, I presume?
Yes, Your Honor, administrative costs are $174.73.
All right, and the notice says here life safety issue, is that to be addressed?
That was something the building official had asked us to place in there because of the fact they had done
They done what, I'm
work
sorry?
they have done the work with no inspections and it was electrical and plumbing. So the building official, excuse me, asked us to put that on there because we don't know if that work has been done correctly.
Okay. But I'm not hearing the town say anything about abatements.
No,
Let's just get the permit in 30 days.
Yes, that's fine, Your Honor.
All right, 30 days should be more than enough time based on where you are in the process. Are you in agreement with that?
Sure, yes.
Okay. All right, anything else you'd like me to hear?
Well, the paperwork that I received, Your Honor,
Mhm.
has been, if you go back up to the delivery of the paperwork, I did refuse the delivery of the paperwork. When I did receive it, when it was posted, things have been crossed out and it's been notarized. I don't know whether, like right there, my mother's name is crossed out and it says 3/17/26. According to notary law, because I was a notary in New Jersey, you cannot cross out anything on a paper like that. It has to be reprinted and re-signed by the notary. So I believe that this is deficient on its face.
Does
I
the
don't-
town want to respond?
I believe she was referring to the affidavit of service.
Whatever that document is right there. I can't see what it's typed.
And that's for the affidavit that
Yep,
we're required
correct.
to do for posting.
Mm.
And the way that the town's affidavit of posting works, is you can attempt first to hand deliver it. And if that happens, you put the person's name in and when it was hand delivered. If you're posting, which was actually what was done, then you notarize the time that you and date that you posted it.
Understood, but she signed and notarized the paper before Mr. Shanahan served it. That's her handwriting right there at 3/17/26. And then his signature there, it's clearly different handwriting.
Well, I guess the question for Mr. Sheehan, was this notarized and then you changed it? Or did the cross out occur before she notarized it?
My date is 3/17 is below there and my signature is right there.
And then you had it notarized?
Uh, Off the top of my head, I can't remember. Off the top of my head, I don't remember.
Can I
But-
speak?
Yes.
Okay. I'm the one that wrote the 317. Basically, we have a formatting issue with our form. It automatically, for some reason, auto populates the name. So before he notarized it, I put the date in there. And then he signed it.
Okay, understood, but it's still, if the law is the law for notaries, I mean, you should have gone, able to have gone back in, taken that out and put the 3/17 in that space.
Let me see if I can simplify it. Is the town relying on the posting for service? Was that the only mechanism
I
of?
believe we have both. I believe we have certified mail and posting.
Correct.
I
There
believe
is
your
both,
mom
yes.
actually.
I'm just saying, you know, but I got the paperwork in general and for first, I mean, I didn't take into account anything about it because, you know, there's a way to do it. That's all I'm saying. I can comply with the 30 days, no problem. I'm already in touch with my plumber to get that all redone, no problem. But I don't agree to paying my court costs, stuff like that. I think that's a little hefty for a violation that really, in my opinion, wasn't properly served to me.
Well, so what, and can I ask the town clerk, can you scroll forward to the certified mail? So your point is very well taken on the notary document. I don't know whether that was
My mom
crossed out
doesn't.
before or after, but it doesn't change legal sufficiency. Chapter 162 requires them to send you certified mail. If it's signed for, that's legal service.
Okay.
In this case, it was legally served. If they didn't have this, your argument would likely have prevailed because
So my mom did
I
take it
agree
out
with
then.
you. Yeah, I agree with you that documents shouldn't be changed, especially notarized documents. So, but I don't think that's dispositive here because there was a signed certified mail. The town always, just so you know, in code enforcement, they always post because they never know if they're going to get the certified mail
Understood,
back.
understood.
So that's why the posting is a lot of times duplicative.
Mhm.
But your argument is a good one. It's a very astute argument to bring
Thank
here
you.
this morning. So definitely a good one.
Okay.
I'm more concerned about you getting the permit
Yes,
because
absolutely. I'm in touch with my plumber. Like I said, he will reapply for that and get that done so we can have all those inspections wrapped up.
and it's in your
30 days.
best interest to get it all permitted.
Absolutely.
You don't want to have
Oh,
work
no,
that you
yeah,
don't know if it's
absolutely.
done correctly. So it's
Right, and the
everybody
master permit
benefits.
is in right now as we
Right.
speak. So that should be, like you said, in 1 to 2 weeks should be issued and we should have no problems.
Okay.
Going forward.
All right. So, and then keep in touch with the town. I'm
Mhm.
going to give you the 30 days. I think that's more than enough time, but if you
Okay.
should have any reason that something out of your control is happening, that you
Sure.
are not going to comply,
Okay.
communicate with the town, because they're usually very receptive to things that you can't control.
Okay.
Now, that's not the same as on the 29th day, you call
Oh,
the
yeah.
town and say, we did nothing, but we need more
Right.
time, right? Don't do that.
Okay.
Be diligent with your contractors and make sure they
absolutely.
understand that you're under the gun now. And a fine starts running on that 31st day. So you don't come back to to another hearing. If the town will go and they'll look at their files on the 30th day and see if there's a permit issued and see if you're complied. And if you're not, the fine will start the next day.
Sure,
So,
but, and also for the record, the only work that was being done was being painted at that moment. Nothing was being, done, further than that. Because
Okay.
all that was replaced was, under, my understanding and our contractor's understanding in that meeting was that the sheetrock came down, nothing was changed, the structure wasn't changed, nothing was changed, everything had been inspected up to that point. We're in the terms of our final inspections, which means the electrical and the plumbing, that's to flush a toilet and flip the lights on. So therefore, we're not really in violation of anything, hadn't we already had that inspections done for the
right,
first part.
right.
So what was being done was being painted. That's what we were referring to. Nothing was changed or structurally, everything is exactly the same way that it was.
But you got to get the inspections on the plumbing permit that expired,
Understood.
and you got to close everything out because otherwise it's a violation of not getting the work permitted correctly.
No
So
problem.
it sounds like you're going in the right direction. Keep going that direction and you
Okay.
shouldn't have any trouble.
Sure.
Anything else you'd like me to hear?
No. That's it, Your Honor.
Anything further from the town?
No, Your Honor.
Let me ask you, ma'am, any objection to the documents that you've seen being entered into the record? I heard your objection on the
Yes.
affidavit of service.
No.
Anything other than that?
Mm-mm.
All right. With that, in case CS 2026-0026, I'm sorry, I'll enter the town's evidentiary case file as composite exhibit 1, over objection. I'll find based on the certified mail having been signed for that the town had legally sufficient service to proceed with today's hearing. I'll find based on the testimony of the town as well as the respondent that the respondent's in violation of sections 6731A, 6751A, and 105.1 of the Florida Building Code. And I'm going to require you to comply with those sections. What's the 30-day date? What's today, the 6th, 7th?
Well, it's the 7th.
Yeah. 7th.
That'd be May 6th.
Yeah, there's 30 days, so yeah, May 6th. So your order will say comply on or before May 6th.
Okay.
Or a $100 per day fine will be assessed for each day that the violation continues thereafter. So again, if you're not going to get the permits issued by that 30th day, communicate with the town and make sure they understand where you are. I do have to, because I have found you in violation, the town is entitled to its administrative costs. There are costs to get you to a hearing. There are certified mail costs. There are a multitude of costs to get you here. So I'm going to assess those administrative costs today in the amount of $174.73. Those are payable within 30 days.
Okay, sure.
And you'll get an order that reflects all of this in the mail, okay?
Great, no problem. Thank
All
you.
right, great, thank you.
Thank you. Your Honor, I believe we have one more respondent. Is it Ms. Cantor? Okay.
All right, is that number 9?
Not sure, but
Sorry.
Yes, number 9.
the case number CS 2026-0008. The property address at issue is 7 Ocean Harbor Circle in the town of Ocean Ridge. The violations cited on the notice of violation involve a nuisance issue dealing with pilings and dock, 6481. Work without permit under section 67-51A. Maintenance requirements, section 67-174A. We have the town's code officer, Steve Sheehan, present to testify, along with the town clerk, Kelly Avey, to testify on behalf of the town with regards to notice. Mr. Sheehan, if you want to start, provide the basics on the case.
Good morning. I was led to 7 Ocean Harbor for some deficiencies and some violations. I got into the property's neighborhood and noticed, the first thing we noticed was the pilings on the dock, um, completely rotted out, safety issue. Uh, One of the pilings is completely not even in the water anymore. So it's a safety issue. I believe it's that second one there from the bottom. It's not even touching the water right there. And then the dock has got a slant to it, so it looked, as a life safety issue, it looked pretty dangerous. You could see it's coming, it's slanting downward toward the picture from where I'm standing. As I was there that day too, there was some tape from the homeowners association to block it off so that no one could go on to that area. Also noticed on the property some exposed, well, there on the front door was some work being done without a permit. As you notice, that is a life safety issue as well because there's no handle or anything. So that door is right now not, technically it's not an egress because you can't use that door to get in or out as a life safety issue. And then I also came across, this is from the street, that the particular picture from the door and this particular picture was taken from the street. That's some landscape lighting with some exposed lights. I mean, excuse me, some exposed wires. So that's what we came across, at 7 Harbor or Ocean. There's the, tape from the homeowners association, I was told. And you can see that the dock there, that's a good picture right there. You can see how, in comparison to the seawall, how from the picture from the right, how it goes from right to left, that it's not level anymore. And that picture right there was the posting of the notice of violation. Because when I went there to go serve the notice of violation, there was no respondent at the door or anything like that. So I just posted it as I'm supposed to and take a picture.
So let me just ask a question just so I understand. You're talking about the homeowners association. Whose dock is this a single family house or is this a?
Single family home, yes.
So whose dock is it? Is it the HOA's dock?
No, it's the property owner, 7 Ocean Harbor. The respondent.
But the HOA blocked it off?
That's what I was told.
Okay. Okay, go ahead.
So that right there, that's a picture of me posting the violation and, and of all the 3 violations of working without a permit and the life safety of the dock and the rotting pilings on the dock.
All right, Miss Avery, do you want to go ahead on the service?
Okay, bear with me. We delivered it or sent it certified mail on the 12th of March. And it was not delivered as she was not home. She did get knowledge of it. I'm not sure if it was sent to her or whatever through another means, but she did call me. Was it Thursday? Last Thursday. She did talk to me about that she had received it. So she spoke to me and then I had given a message because I was leaving. The next day I would not be there. So I gave a message to have the code enforcement officer speak with her. That's where I left it. So I do know she received it.
And there's an affidavit of posting, is that also correct?
Yes. Yes. Same thing. V12.
All right, any further witnesses from the town?
No, Your Honor.
All right, ma'am, is this you?
Yes.
All right, can you come to the podium for me? Your name is?
Ilona Cantor.
Okay, thank you. So you've heard what the town is saying, a couple of issues. One is the dock, the other is I guess, a new door with no handles and some exposed wiring. You want to go ahead and explain?
Okay, the posting was noticed by someone who helps me out, because I haven't been home since June,
Okay,
so about 9 months. And I had her, I don't know, what day was this? The 12th, well, she mailed it out on, I think, the 18th. Priority mail, supposed to get to me 1 to 3 days. It got there on a Monday, 5 days later. And I'm aware of some of this stuff. Definitely the dock. Yeah, I don't see the pilings because I'm not out on the water.
okay,
So it's kind of new to me. Not, it's a little older than this, but it's new to me. Nobody else's pilings did what my pilings did, so I don't understand that either, but. Like
in terms
you
of
said-
rotting, you mean?
Yeah.
Yeah.
It's set, I mean, it's like, my next door neighbor had a wrapping done.
Mm.
And I inquired about wrapping, but they said it wasn't wrappable, so. So basically it's a new dock, so I get that. I spoke to. I called the Marine, Ocean One Marine. And they called me back this morning, and the owner, Dale Abbott, is going to speak to me after this meeting. But the lady I spoke to, Anna, she said it's gonna be hard because of the weather. I don't know what the weather has to do with anything, but they're working on number 9 in my community right now.
Okay,
So they're actually docked there since yesterday. So I don't know what I'm supposed to say. Like, I understand what I'm supposed to do, which is get a new dock.
and is the front door new?
No, it's an old door that I was having, so the landscaper apparently had the water pointing at my door. It took us months, if not a couple years, to figure out, because he waters at, can I approach and show you?
Show the town attorney first.
Okay. Oh, okay. Right. Gotcha. So. Yeah. Show it to Steve. He'll take this. This is.
You want to show the magistrate your picture?
So what was it? Sprinklers are watering your door? Is that what's? Yeah. Oh, okay. 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 Do me a favor and just go to the microphone so it picks you up on the recording.
So yeah, so I don't think there's a permit required to strip the door, right?
So that was my question for the town. Yeah, if it's not a new door and it's just being sanded or whatever and repainted, does that require a permit?
From that point of view, I didn't know if it was a new door installed or what, so, but no, to paint, no, you don't need a permit to paint the door, no.
But they do need to get the door handle back on.
Yes, oh, yes, definitely, life safety issue.
Yeah, I got the sprues yesterday. at Home Depot.
All right, and the landscape lighting, the exposed wiring, your landscaper will
My
fix
whole
that.
landscape lighting is shot, so I'll be switching all that out.
Okay.
Yeah.
Let me ask the town, what is the town seeking in terms of remedy in this case?
Your Honor, since she testified to the door, we can dismiss the work without permit violation. Just make sure you get the handle back on so it's not a life safety issue.
And that's 6751A and 1051.
Yes, Your Honor. For the dock and piling, we're going to require a permit to replace the dock or the pilings, whatever needs to be done. The timeframe for that, we're gonna need to figure that out because it might take some time to get the
Will take
permit
some
in. What do you think, Miss Avery?
With having to get DEP and Army Corps, it takes a little while.
Yeah.
I would say, I know I've seen them come in as short as 3 months, but I've seen them take over a year too. It just depends on how quickly or what the issue is.
It's a concerning issue, Your Honor, but I think if we gave her 6 months to come in with the permit, that should be plenty of time.
Mhm.
Obviously, if you run into an issue with DEP or Army Corps, just stay in touch with Ms. Avery and we'll work with you because it can take some time to get that. So we would like for 6 months. And if it's not achieved in 6 months, a fine of $100 per day. The landscape lights, that shouldn't take too long to either fix them or take them out. So we would say 60 days or $100 a day. Would 60 be enough time for 60 days?
Yeah, it should be. I mean,
Do we need a permit for that?
Yes,
For the, since it's
It's
electrical?
electrical.
Yeah, if they're just removing it, they just need a permit to remove it all?
I don't think for removal they would have to. It would just be, I could be wrong on that. I don't know what they'd have to cut. And I would probably,
To remove it, you would need to because you were dealing with the exposed wires and it's a safety issue and it could become a liability issue. Even though it's low voltage, you could still get hurt.
so this is low voltage because I want to switch to like the.
Most landscape
latest
lighting, I can't tell 100%, but
it's
most
20
landscape lighting is low voltage, but you still need a permit.
2000, well, not the permit. I'm just saying, could these wires be reused? Or
I
are
can't
they-
tell.
Okay. Well,
You know, they would
it'll
have
be
to
a
look
whole
at it
new
and assess
job.
it.
Yeah.
So we'd ask for 60 days on that.
Okay. And-
And the town's costs are $174.73.
And I think, because the dock was cited for condition of the dock, technically compliance is not until a new dock is in, right? So it's not just about the permit.
Your Honor, yes, but we are talking a year timeframe then, I think, if we want to go all the way to dock completion.
Is there a mechanism in the town, remind me, is there a mechanism in the town code that if I give 6 months now and she demonstrates good faith that she can make a request to the town and come back before me for an extension?
We can just put it on an agenda, if we come into agreement to ask for an extension.
Okay.
Yeah.
Is the town amenable to that?
Yeah,
Because
yeah.
I'd like to make sure that, not that I have any evidence here and I don't believe that you're going to proceed in a quick manner, but I agree with the testimony of the code enforcement officer that, and I think you actually reaffirmed it as well, that the condition of the dock is a serious thing. So I'd like to give you the 6 months, knowing that the permitting is its own issue, but actually compliance in this case is getting the dock repaired or replaced, whatever you're going to have to do. So I'm inclined to give you the 6 months. And then if you demonstrate to the town, if you can't get the dock replaced in that 6 month period, call the town. They'll try to get you back on an agenda so I can give you more time if you've been pursuing in good faith and doing your due diligence and you just can't get it done in that time frame. All right.
I'm going to get someone over to see just how dangerous it is. I don't see a slant to it whatsoever because it would be separating from the wall. I walked on it because that's how I am. But it's scary. I watched this show on horrible things at weddings and this girl wanted the wedding on the dock and they put a new dock on the old dock and her dad ended up in the,
In the drink.
Right.
Yeah.
tragic. As far as uh, permits. I can't even conceive of doing anything without a permit. I have had a pool heater, a pool filter, a water heater, a garage door opener, 4 to 5 roof repairs, and an entire wall of my house in 2 areas taken off. Permitted.
And you definitely want permits for the dock, because they will,
Oh,
there are more people in the
yeah.
town that'll
Your
come
Honor.
after you.
Yeah.
One other suggestion that Mr. Sheehan just made, is also to come into compliance, the quickest would be to just remove the dock.
That was gonna be my next question. Is it a mandate of the HOA that there be a dock there, or is it?
I can't speak for the HOA. I'm just thinking life safety because I know what I saw. And if we can, I understand that getting a permit to rebuild a new one can take maybe up to a year and then some to rebuild it. I was just telling her, I've been thinking out loud here, maybe we can expedite a permit to get rid of it and at least have it gone so that there's no life safety issue.
But I
And-
think they might,
But I don't know about the HOA.
they might have installed too, because otherwise you're walking down those stairs and there's
Into
nothing
nothing.
there.
Then
Yeah.
I'll have a life safety issue.
Yeah, then you'll,
When my 90-year-old goes.
Yeah.
again,
But you may want to look at that, because their point is a good one, that
Mm.
if you're not required to have the dock, that's your own
because
personal
if you remove the
decision,
dock,
but
then you're in compliance.
you're out of code enforcement trouble is her point. That
As long
But
as,
then I'm literally
right,
falling into the wall.
correct.
I don't think I'm removing the dock.
Okay.
I don't
Okay.
think I'm
Yeah.
removing the dock. I mean,
just an option, but yeah, how you comply, I don't prescribe how you
Yeah.
comply. I just give you sufficient time to do
I'll
it.
get that structural person to tell me, like, what can I do? I mean, I still go out there, but that's, I'm scared now.
All right, let me ask you a procedural question. Do you have any objection to the documents that you've seen on the screen being entered into the record, the pictures and the notice documents? Okay, anything else you'd like me to hear, bless you, for this morning? Anything else you'd like me to hear this morning?
No, we're good. And yeah, I take that doc very seriously. I wish I was told about it when I could have wrapped it, but I didn't know. And I'm not here that much. Sometimes I'm gone for even like 22 months at a time. So, it would have been great. Like everybody's looking at my house because I'm on a little horseshoe.
Mm-hmm.
So yeah, because I'm getting attacked from my HOA as well. So
There probably is a requirement for you to have the doc then, but
Yeah.
it's good that you showed up to this hearing, because the benefit of coming to the hearing is you get the time that you need, and people don't proceed with cases
will
without
tell you-
you, so.
I flew in for this meeting. I am very sick. It took me a week to get on a flight because I couldn't do it. And yeah, so I'm here. I'm glad I made it too.
Yes. All right, anything further from the town?
No, you're-
All right, with that, in case CS 2026-008, I'll enter the town's evidentiary case files composite exhibit 1 without objection. I'll find based on the affidavit of posting in the case file that the town had good service for today's hearing. I'll find based on the photographs in the case file and the testimony of town staff that the respondent's in violation of section 64-81 and section 67-174A. I'll require a respondent to comply with section 64-81 within 60 days, or $100 a day fine will be assessed for each day that the violation continues thereafter. And I'll require a respondent to comply with code section 67-174A, that's the dock, within 180 days, or $100 a day fine will be assessed for each day that the violation continues thereafter. Because I found you in violation, I'll award the town its administrative costs for today's hearing. That's in the amount of $174.73 payable within 30 days. And you'll get all this on a piece of paper on an order after
Anna,
them.
Did you say for the doc 180 days or 6 months?
180 days, same thing, 6 months. You're good. And keep in touch with the town.
And
So
+2 is.
yeah, my order won't say, but keep in touch with the town as the 6 months goes forward. But I would encourage you to get in touch with the marine contractor as soon as you can, because it is a
We're
process.
Talking after. this.
Yep, okay. Thank you, ma'am. Good luck.
Thank you.
Has to be up front. Yeah. Yeah. Thank you.
Thank you, ma'am.
Thank you. Thank you.
All right, is that all the contested cases?
Yes, Your Honor.
So back to the beginning.
Yes. Your Honor, I think our next case is case number 3 on the agenda I have in front of me. That's case PD 2026-004. The respondent is Davia Douglas. And this is a parking citation. We have an officer here to testify.
Go ahead, sir. Do me a favor before you continue. I'm sorry to interrupt you. Get that microphone a little. Yep, perfect.
Good afternoon. My name is Officer Sassoff. Just want this.
Is it in the computer or no? Okay, fine.
This. Hammock Park. I'm sorry. There's a sign says you're only allowed to park on parking spots. Or into Ocean Ridge, city ordinance as well. You're only allowed to park in the parking spots. On December 26th of 2025, so if the car parked not in the parking spot, then it says no parking as posted. So issue a parking ticket. Placed on the windshield, took a picture and left. And you can clearly see on the picture, no parking between the signs.
And what, I guess you confused me a little bit. This is a county code sign. So connect the
It's
dots for
city
me.
and parking. There's a sign that says no parking. So we have a sign that says no parking unless it's designated parking spot. It's two signs pretty much, one that you come in and one that's on the side of where they parked.
That's the picture of the vehicle. Says no parking between signs.
Yes,
All right, but you cited a town code section 54.2, right?
Yes.
So this is really not relevant then?
it's not,
Okay,
it's two signs. If it
Okay.
makes sense.
all right, but that white and red sign is a town sign, right?
Yeah, I think it's confusing because it's a county park within the town. But the red and white sign is the town sign.
Okay. All right, and how does the town have service?
Through certified mail, which Ms. Avery has included her documentation and showing proof of delivery.
And officer, what's your first name?
ALEKSEY.
Thank you. Okay. All right, Miss Avery, do you want to testify to service?
Sure. We sent both certified and regular mail. They initially were scheduled for the February, sorry, I think it was February meeting. March meeting, sorry, Wade canceled that. They received that one. And then we rescheduled it, sent them a notice, another notice of change of date to the April 7th, sent it certified and regular mail. That one for some reason did not get delivered. But we were, as of this morning, I did check and they still have not paid.
Is that delivery confirmation tracker from today?
No, this one is not of today. That was of Thursday, I believe. Usually when we get those, they send them right back.
Do you want to check again and see right now if it's been delivered?
We can check. I haven't
Because the citation wasn't signed for, right? It was left on the car, is what you said?
That is
Right,
correct.
yeah.
They did receive the first one.
Yeah, but that's for
Yeah.
last month's
Yeah.
hearing.
Yeah, I do have two more parking tickets if you want to talk about it.
Yeah, it's fine. Do you want to go to the next one and we'll come back to that one?
Next one's gonna be
Still saying update.
Right, so we'll have to continue that one. See if we can get service on it. I think the next one has the same issue, doesn't it?
But I can't even do an order continuing without service for today. Is it the renotice?
Yeah, we'll just take it off the agenda
Okay.
and renotice it for the next hearing.
All right, so it's PD 2026-004 is pulled.
Um, Number 4, 2026. 2026-005. On that one. We don't have proof yet in that one either, do we? So we'll take that one off the agenda. In 2026-06.
That one was signed for.
Back to the town. Oh. Kelly, which case is that?
PD 2026-005.
So the respondent is Daniele.
Correct.
So the certified mail is showing as delivered.
It showed delivered, but it said delivered to the original sender, so I'm not sure what that means. I think it, in my opinion, that would be, it was coming back. I haven't seen it yet, but it said it was delivered on Saturday. I wasn't here yesterday, so I didn't see anything. It could be on my desk. I could go check if you want me to.
Is it red or is it green? Do you still have it
Green.
up?
It's green.
Can I see it? Show that to how much. I think they're usually red if they're returned to sender,
Right.
but I'll defer to the town if you want to proceed.
You can- That's okay. Since it says delivered, we'll proceed. Because for this parking citation, the person's from North Carolina. Ms. Avery, do you want to just double check that you don't have anything on your desk? Since you
Oh,
weren't here?
that doesn't make sense though, because it said delivered to Boynton Beach.
Right,
So
so
it
that's,
thinks you're in Boynton, but
yeah,
it was sent to North Carolina.
the initial that's included backup was that, I thought it went there. Because it was originally processing in Greensboro. Oh, it was unclaimed and returned. So we
It
should be,
came back, yeah.
yeah, it came back. So
Sorry.
that's okay.
Usually
Next
they're
one,
green.
right?
Yeah.
Right, that one's a little old. So the next one is PD 2026-006. And that one is, I believe, properly certified mail. Correct.
We have the green card.
Yep. This is the PV Holding Corp. Yes. That's Pylon's. Officer Pylon's case.
You may be seated this time, sir. If you'd like to be seated, you may be seated.
We're 2 hours into it. We're
I'm
good.
so-
No, you're good. Will you let me see the top of it again? All right, on December 29th, 2025. Sorry, at around 3:36, I think that says, while patrolling, scroll down a little for me. The Hammock Park area, which is the same park where he wrote the citation earlier, I observed a vehicle that was improperly parked. Can you scroll up so I can see the photo again? There we go, perfect. Yeah, obviously it's parked in the grassy area. They try to do that to when it's full, they'll pull over the curb and just park wherever they can fit their car. So it was issued a citation. I don't know if you remember that big truck we had where he
Mm,
where he parked in between.
in the landscape island or something.
Yeah.
Yeah. All right, and Miss Avery, it looks like you have a signed certified mail on this one. You sent a notice of hearing certified.
Correct.
All right, what's the town seeking? The fine amount hasn't been paid, I presume?
That is correct.
This is a $40 one. The citation says $40.
All right, so
And
you're seeking $40.
$40, court costs of
Plus-
$184.88.
All right, anything further from the town?
No, Your Honor.
All right, in case PD 2026-006, I'll enter the town's evidentiary case files composite exhibit 1 without objection. I'll note for the record that the respondent is not present. I'll find based on the signed certified mail in the case file that the town had good service for today's hearing. I'll find based on the testimony of the officer as well as the photographs in the case file that the respondent's in violation of section 54-2, and I'll reaffirm the $40 citation fee, which remains unpaid, so I'll assess that $40 fine. And I'll also award the town's administrative costs for today's hearing in the amount of $184.88.
Next one we have, Your Honor, is case number PD 2026-007. The respondent is John Carvet Jr. This is a parking citation from Sergeant Pylon. I think we have service in this one, don't we, Kelly?
The second one we do not.
Oh, the second one we don't? Oh, okay. We will remove this one then, Your Honor.
All right, number 6 is being
Yes.
removed. Okay. And for the record, 4 was removed, right?
Yes.
Okay.
I don't think for the next one, do we have?
Nobody on this one either.
Alexander. We don't have service for that one, do we?
No.
No. Okay. So then the next one we did, Mull.
This one specifically, I talked to the general contractor in reference to parking vehicles on the lot.
Okay.
And they can't park. If you look at the picture, this is a vacant lot park.
Yeah, we just don't have good service on them, so we can't take it forward. We can try to get them served and set it on another agenda, but I think that's it. The other cases we've heard.
Number 10 is still.
Oh,
15.
thank you. Old
Yeah,
Ocean.
number 10.
That's the last one.
Yes. You guys are done.
Yep, we're all good. Thank you, officers.
Thank you.
So this last one, Your Honor, is case number CS 2026-0023. This is for the property address at 5015 Old Ocean Boulevard. The property owner is 5015 Old Ocean Ridge LLC. The nature of the violation is a repeat violation for encroachments of the right of way. We have, I believe, Mr. Sheehan and Ms. Avery here to testify as to this repeat violation. And Your Honor, I have the underlying order finding the original violation.
Okay. You. All right, go ahead. Whoever wants to go first.
Okay, I will on, believe it's 312. 312, I served a notice of violation for repeat offense of vegetation encroaching into the right of way of Old Ocean, causing walkers, bicyclists, and cars to veer out of the way of the vegetation. Pictures to support that.
Is that photo that's on the screen right now, is that the compliance photo?
Yes, correct.
And how does the town have service in this case?
A notice was sent out on March 16th. We do have proof of delivery via the website. And they did contact me and told me that they did complete it. We checked it and everything was good.
And what's the town seeking today?
Your Honor, since this is a repeat violation, obviously the town can go from the date that the repeat violation was observed. I'd like to go from the date that they actually received notice of the repeat violation. In this case, they received a certified mail, I believe on the 23rd. Was that the date, Kelly? The 23rd?
The 16th was when we sent it out.
But when did they actually receive it?
Oh,
On the 23rd?
yes.
On the 23rd, and then the date of their email where they sent us the photograph of compliance was 8 days later, so that would be 8 days of repeat violation. And we would seek a repeat violation fine of $500 a day, so for a total fine of $4,000. Your Honor, this property is an issue for the town. As you can see from the other photos, there is another pending code violation, a lien actually on the property for maintenance standard issues because the property is boarded up and has other issues. And this is obviously a repeat violation. And we're trying to do our best to get this property owner to start maintaining the property without the town having to intervene in that process. So that's why I'm asking for a $500 day fine amount for the 8 days they were in non-compliance.
All right, and you're going off of you're going off the email from 3/31? Is
Correct?
that correct? Okay.
Yes.
From what looks to be a realtor, so is it for sale?
Yes.
Stay in my lane, stay in my lane. All right, and you're looking for your administrative costs? In the
Yes,
amount
Your
of
Honor, thank you.
174.70. And then, just for the record, so this you said is a repeat and you handed me an order finding repeat violation, assessing fine and imposing lien for case 2025-048. So this is a second repeat then?
Yep.
All right, so this order was from June 3rd of 2025 and the original violation. The order finding violation, assessing fine and imposing lien dated July 2nd, 2024. So you're certainly within your 5-year time frame. All right, it does not appear that a respondent is present.
That's correct, Your Honor.
All right, anything further from the town?
No, Your Honor.
All right, in case CS 2026-023, I'll enter the town's evidentiary case files composite exhibit 1 without objection. I'll ask the town to put a copy of this previous order in there just so it tracks with the file.
Okay.
I'll find based on the notice documents in the case file, which include USPS confirmation of delivery for the notice of hearing that the town had good service for today's hearing. I'll find based on the photographs in the case file and the correspondence between the respondent's realtor and the town that the respondent was in repeat violation of section 34-162A for the period from March 23rd, 2026 through March 31st, 2026, a period of 8 days. That repeat violation is based on a previous order finding violation, which was dated July 2nd, 2024 in case number 2024-009. So given the repeat violation, I'll assess fine against the respondent in the amount of $4,000. That's a $500 per day fine for those 8 days of repeat violation. And because I found respondent in repeat violation of the listed code section, I'll assess the town's administrative costs in this case in the amount of $174.73 payable within 30 days.
Thank you, Your Honor.
All right, and that appears to conclude the agenda. Is that correct?
That's correct, Your Honor.
All right, with that, I'll adjourn the hearing at 12:28. Thank you.
Thank you, Your Honor.
Do you mean to reopen?